That's Kuala Lumpur for you. If it's not the flash floods, it's usually the traffic that's close. Please have a seat. Oh, and by the way, this is Sarah. She's my intern. She'll be doing note-taking today. Okay, well, welcome, Miss Anisha. I have to say though, I feel like we're somewhat underdressed for the occasion.
Don't be. I'm a job hunting. Hence the formal attire.
Right, I bet it's been a very long day for you, but I hope you're still in good spirits because we'll be going through some things that you submitted via the Google form on our website.
Yes, I'm still doing it.
Okay, great. Before it slips my mind, I would like to reconfirm with you that you have agreed with the legal firm fees that I have quoted via WhatsApp for this consultation and any subsequent consultations.
Oh yeah, I'm okay with it.
Alright, Miss Anisha, what's going to happen today? Firstly, we'll go through the events that brought you here today. Secondly, we'll discuss your expectations and what you're hoping for. Thirdly, we'll break down what needs to be proven or shown to support your expectations. Fourthly, we'll look at the possible solutions aligned to your expectations and entries of the law. So is that all understandable?
Yes, I understand.
Okay, so from what I gathered from the Google form here, you are a director and general manager at WV Services Malaysia Sdn Bhd KL, effective 11 December 2015 until your date of termination 23rd June 2022. You believe that you were unlawfully terminated on this date. Could you expand more on that?
Okay, sure. Okay, actually, I was appointed director on 11th December 2015 and on the 1st May 2016 I was appointed as general manager. All was going well, but on 23rd June 2022 when I was working from home, I received a short termination email from my company and there was no reason given in the email and no domestic inquiry initiated by the company. So I have been out of work since then.
Well, that seems extremely unfortunate. I'm so sorry, Miss Anisha. But didn't HR have anything to say about this?
I went to HR that day and demanded an explanation. They simply said that the decision came from the top management. When I threatened legal action, they told me that I had no legitimate expectation of continuing employment, especially after my previous termination.
Previous termination? Oh, can you please explain to me what happened during this previous termination?
Well, on 4th December 2020, my company fired me from both my positions, but I still remain on the board of directors, just without any salary. Then, on the 15th November 2021, the company reappointed me as director and general manager, both on payroll.
I see. That's important information that may help with your case. Also, I've noticed as per the documents that you emailed yesterday, you and the company have already gone through reconciliation meetings with the Director General of Industrial Relations, but the company failed to show on the hearing dates dated 28th August and 25th November 2024. Is that correct?
Yes, that's accurate. They didn't want to settle things out of court, as it seems.
Some companies are somewhat tricky to get around, but it's alright. We're here to help you. However, you also mentioned that you were paid again after the first termination. How much was that? And you remember when was your last drawn salary?
So, my last drawn salary was on 25th June 2022. I received 68,836 ringgit and 11 cents per month with a monthly allowance of 200 ringgit. Since the terminations, I have not received a stable job, hence why I wish to make a claim for unlawful dismissal against my company.
Right, so I will need your salary slip emailed to me, but other than that, all the documents and your facts are set straight, and I think we're making great progress. But now, I need to make it clear to you about unlawful dismissals under the IRA. As you may now know, since the conciliation meeting has been done and the matter remains unsettled, the only way forward is via the industrial court. So Section 20 of the IRA states that the industrial court decides whether your dismissal was lawful or not. So in doing so, firstly, the burden of proof is on the employer to show that the dismissal was with just cause. So just cause may include negligence, poor performance, or misconduct. So if the employer provides no valid reason or evidence, the dismissal is presumed unlawful. Now, secondly, the industrial court applies a civil standard of proof, which is balance of probabilities. This means the court looks at which side's version is more likely to be true. However, the standard is flexible. The more serious the allegations, such as dishonesty or fraud, the stronger and more convincing the evidence must be.
I understand. Then, based on the documents I have emailed you and today's consultation, may we proceed with the split?
I believe so, since there hasn't been any concrete reason or any inquiry done by the HR of your company.
Then what happened next? Are there any remedies for me if you can prove this?
Certainly, there are 3 remedies for wrongful dismissal. Firstly, reinstatement as per section 20, subsection 1 of the IRA. Secondly, compensation in lieu of reinstatement. And lastly, back wages as per the second schedule of the IRA. Do you have any idea which one you'd be more inclined to?
To be honest, I will need some time in this group. Anyway, I think it's getting quite late. Can we schedule another session next Monday?
Monday, I think online session could be okay.
Yes.
Around the same time right now?
Yes.
Okay,
yes.
alright. So
Thank you for today.
Thank you so much.
Thank you so much.
Hi, how are you, Miss Alicia?
Hi, I'm doing well. How are you, Miss HANIS?
Okay, I'm doing good too. Just wanted to introduce to you. This is Miss Fatin NAJWA. She's my partner and senior associate at the firm.
Hi, Miss Alicia. Nice to meet you. I'm here to further discuss where you two left off last week, which is the remedy that we can help you with.
Yes, that's the only thing we did manage to discuss the other day. I'll be the note taker today, and I'll leave it up to my senior associate, who's more of an expert in this field, to help you today.
Alright, firstly, may I know if you have any preference on what your remedies are if you win this case?
Okay, I think I would like to go back to my job, but after how they treated me, I'm not sure. They treated me like garbage after I was fired. It was horrible.
Alright, reinstatement is the primary remedy as per section 20, subsection 1 of the IRA. However, considering your exit from the company was hostile, it might not be ideal to return. In our experience, in handling cases similar to yours, the court leans toward awarding compensation and back wages instead.
So, am I eligible for compensation or back wages?
In all likelihood, you may not receive compensation since compensation in lieu of reinstatement can only be claimed if there is at least 1 year of continuous service. The court might just consider your service clock to be reset when you were rehired in November 2021.
Well, then what other options am I left with?
You can definitely claim for back wages since you have been unemployed for more than 2 years since the termination. You qualify for the full 24th month of back wages allowed under the law.
Great. Then how do I calculate the amount?
Your last drawn salary plus allowance totaled to 69,036 ringgit and 11 cents per month. This multiplied by 24 months totals to 1,656,866 ringgit and 64 cents.
That's a quite large amount. I honestly did not expect it to be that high.
Yes, it's a huge figure, but it seems to means to reflect the loss of income you have suffered due to the unlawful dismissal. However, it's important to remember that this is subjected to the court discretion and any mitigating factors such as interim earning or contributory misconduct.
I understand. So, what should I do next?
On our part, we will issue a formal letter of demand to your former company This letter will state your intention to claim the back wages.
And what if they don't respond to the letter? I have a feeling that the company wouldn't even bother to entertain it, since they didn't show up to the conciliation hearings.
If the company fails to respond or refuses to cooperate, as they did in your previous conciliation session, we will then proceed with the court action in the industrial court. Then we will file the appropriate document for the litigation process.
Will I have to attend the court often?
Not frequently. You will likely need to attend the main hearing to give evidence and for the cross-examination. But we will handle all the procedural filing and the submission.
Okay, right. There's also the option of alternative dispute resolution. So the chairman of the industrial court still encourages you to go to mediation even after a dispute is referred to the industrial court. However, for your back wages claim, it's unlikely that you would recover the full amount through mediation.
I see. So, based on what you have explained, the industrial court would be the better option if I want to claim the full amount of my back wages?
Exactly. The industrial court has the authority to award the full sum of back wages if it's found that the dismissal was without just cause. Mediation, on the other hand, focuses more on achieving a mutual agreement, which often involves compromise on the total amount.
That's right. Since your case involves over 1 million ringgit and clear non-compliance by the employer, the industrial court would provide a more structured and enforceable outcome.
Understood. Then I think it's best we proceed with filing the case before the industrial court.
Right, me too. I think so too. Before we finalize the filing, Ms. Alicia, I'd like to check. Have you been managing all right financially since the termination? Are there any pressing commitments or dependents we should be aware of?
Well, honestly, it has been quite difficult. I have been unemployed since 2022, and I have two children to support. My mother's health isn't that great either, so I have been helping with her medical expenses.
We understand, Miss Alicia. Those are valid circumstances to highlight in your claim. The industry court often consider financial hardship when assessing the equitable amount of the back wages.
Also, have you tried applying for social assistance? You may still qualify for temporary income benefits.
Oh yes, I have already applied for SOCSO since before the conciliation meeting took place. I was told that I can still apply even in an ongoing case.
That's good to hear that. Keep all sorts of related documents. We can include them as part of your financial background when presenting the case. It shows your continuous effort to mitigate your loss of income.
Oh, okay. I understood. Thank you, Miss Hanis and Miss Fatin. I really appreciate how thorough both of you are.
Alright, before we conclude today's session, allow me to summarize the post-consultation action. A written summary of the discussion will be prepared, incorporating the remedies considered, computation of back wages, and the selected course of action. The billing record for today's consultation will also be updated accordingly. Subsequently, we shall proceed to draft the related document and compile all the relevant supporting document, including the appointment letter, pay slips, termination letter, and DGIR conciliation record for the purpose of filing the matters before the industrial court.
That sounds very organized. I appreciate all your help and effort.
You're most welcome, Miss Alicia. We'll send you a copy of the LOD and we will keep you in the loop for any subsequent documents and updates via email and my WhatsApp.
Oh, okay. Thank you so much, Miss Hanis and Miss Fatin. I feel much more confident about the next step now.
That's great to hear that. We will stay in touch and keep you informed on any updates. Have a pleasant evening, Miss Alicia. Thank you so much for your time and cooperation.